or two to figure itself out. Okay, you're recording. Be sure to let everyone know that they're being recorded. Okay, here we go. All right, so let's start at the beginning. So hopefully you guys all managed to watch that presentation. I gave you a hard copy of the presentation, and I gave you a copy of last year's lecture where I just sort of presented it. So you can see that you know, we're all sort of on the same page. And from that lecture, that's like a broad bird's eye view of patent law, and most importantly, how it sort of fits in with intellectual property law per se, because you'll recall that one of the major slides in that presentation talks about how patent law is one of the big five. So just like we have the big five of species of game, lion and rhino and leopard and that kind of thing, we have the big five in intellectual property, most of which you are familiar with, namely patents, this one, trademarks, which you will have done, designs, which we will cover in this course as well. The last lecture deals with designs, and there will be a question on it. Copyright, and then trade secrets or confidential information or know-how, as it's called, being the fifth one. There are, of course, other... oh, here's Ruda. Hey, Ruda. You're on mute there. Okay, well, anyway, I'll carry on. Ruda, just to let you know, this is being recorded, so and I'll post it on Blackboard in the next day or two. I get back to Joburg on Wednesday. I've got much better Wi-Fi there. Right now, I'm just working off an LTE card built into my machine, which is less than ideal. But anyway, it is what it is. So, and I was telling the others, Ruda, that from here on in, I want the lectures to be face-to-face. You know, the communication is just not as good when we do it like this, when we do it on Teams. And also, I think, you know, it's just nicer just to get around a table. Communication is so much better, and we can talk, and I can hear you guys, etc., etc. So I think that's better. Okay, so we were talking about how patents is one of the big five, and there are other species of intellectual property which don't make the big five. Probably the runner-up, the closest runner-up would be plant breeders' rights. And we will, in fact, discuss them this morning, but it's just something you have to know about the existence of, really. You know, we're not going to go into any detail, but it's important to know that they do exist. They're a big business. I mean, they're really, really important, and they hold a lot of value, but it's not, they're extremely esoteric. They're not for the uninitiated. Most people barely know of their existence, although if you speak to the ARC, the Agricultural Research Council, or the deciduous fruit industry, or the flower industry, you know, plant breeders' rights are hugely important to them because they give monopolies on varieties, specially bred, selectively bred varieties and stuff like that. And that, of course, can be of huge value to that industry. So they're really important, but we'll just touch on them today. Today, we're going to be talking about patents and sort of how they fit in. So patents, you know, at their core, and this is what I want to focus on in this course, is that patents are philosophical in nature, right? And they're unique in the sense that patent law is distinct from other sort of legal frameworks because when you consider it, most other legal frameworks, the Criminal Procedure Act, you know, the Tax Act, Companies Act, etc., they say you have to do this. Thou shalt do this, and if you don't do it, then this is the punishment, kind of thing. So it's very prescriptive. You have to do this. If you don't do it, this is what happens to you. So it's, you know, it's like a parent wagging its finger at a child, laying down the law, literally. Whereas patents, the Patents Act is completely turned on its head. It doesn't say thou shalt do this. It says if you do this, if you supply the solution to a problem which is afflicting society, and your solution is absolutely novel and it's inventive, it's clever, it's not obvious, then we're very grateful for your providing this solution because it makes the world a better place, right? I mean, we no longer have this problem. We can now solve this problem. So we're very grateful for that. And so in return, your reward for giving us the solution is a 20-year monopoly so that you can enjoy the fruits of your solution. So it's an incentive. If you do this, I will reward you. And your reward is 20 years to the right to exclude others from practicing the solution which you've suggested. So it's really cool. And you can imagine it's a really important part of society as a whole, because the government can't solve everything itself. I know it thinks it can, but clearly it can't. So it's really important to incentivize citizens, and to say, if you come up with something, then we're really grateful, and there's this reward waiting for you at the end. So it's a quid pro quo. You give me this, I give you that. And so that's the kind of underlying philosophy of it. So it's not thou shalt do this. It's like, if you do this, you get a reward, kind of thing. And then so obviously thou shalt not built around that, but that's the central tenet of patent law. And I think that's why I like it so much. It's quite cool in the sense that it's this reward. It's offering a reward. It's incentive based, and I think I've always liked that. I've always been comfortable with that as a philosophy going forward. So, and the whole Patents Act is built around this philosophy, in the sense that we look to protect that monopoly that you get, but it's quite a high bar that you have to overcome before you get this monopoly, this 20-year right to stop others from practicing the invention. And there's lots of terms and conditions that come with it, because it's a big reward, right? A 20-year monopoly is a huge reward. You can make a lot of money if your solution is very popular, or if your solution is required in terms of healthcare or improved agriculture or something like that. A lot of people pay a lot of money for that. So it's possible to make a huge amount of money from patents. So it has to be carefully regulated. And as I say, the bar to get that 20-year monopoly is enormous. So, and we will be exploring those terms and conditions, for want of a better word, that sit behind this quid pro quo deal, this incentivization. So that's the kind of idea behind it. And I mean, as an idea, it's been around for hundreds of years. But as you might imagine, initially, it was abused quite badly. It was always the prerogative of kings to say, okay, you're my chommy, you can have the sole right to, make stained glass or practice this method to make wheat or whatever. So they were doled out like as favors by the crown at the time. And that was how they used to roll in those days, right? Less than ideal for sure. But it started from a good place, but as usual, it was just badly practiced. So in the fullness of time, proper acts of parliament were drawn up to try and regulate this, and introduce a sense of objectivity and a sense of reward, as in, if you do this, then you deserve it. It's not just because you're the king's chommy, it's because you've actually done something that's deserving of it. And so it was removed from the king's prerogative, and it became accordance to these objective guidelines that put in place. And so these acts of parliament sort of have been around also for hundreds of years. I think, the earliest English one was, around about the 17th century, the 1650s, somewhere around there, which is ironically, when Van Riebeeck put his foot on the beach here in Cape Town. I mean, it's that long ago that these guys were getting their stuff together. But we in South Africa, I think, only really got a Patents Act, maybe 100 years ago or 150 years ago. And the Patents Act that we're working on now is the Patents Act of 1978, which came into force on the 1st of January 1979, and that's the one that we've had in force. Now, the previous one was 1952, so 52 to 79 is 27 years, and this act of ours has been in place for a lot more than 27 years. So it's a good act. It's closely modeled on the UK Act, the 1977 Patents Act in the UK, and there's a lot of similarity between the two. And we'll talk about that because obviously, as you well know, South African law is a hybrid of Roman Dutch and the law of England and Wales. And so, there's going to be a lot of commonality there, but there are some differences. And we will explore those as well. What's interesting is that, we've had the act has been amended quite a few times along the way for various reasons. But it's really being scrutinized at the moment. There's a white paper out there about things that are going to be done, and they're quite far-reaching, really, these proposed changes. And so there's an IP policy document which is out for discussion, and things are moving. And one of the big things that is coming, and this is actually, the wheels have turned, is that South African patent applications will now be examined. And we'll talk about this a lot going forward, but there is a cohort of examiners that has been trained up at the Patent Office, and that training has been as a result of not only in-house training by CIPSI, the company's Intellectual Property Commission, but also the European Patent Office have piled in, the Japanese Patent Office have piled in. All the patent offices around the world have really, come to the party, helped train up our examiners. Now, I think we only have about 20. There will only be certain subject matters of patents that will be examined, but they're starting now. So what's actually happening is having a phased rollout, and they will start issuing non-binding opinions on the patentability. And that's going to be really interesting. Myself, I'm really looking forward to that, because I think it's going to be great to engage with these guys and sort of argue with them. Because, I'm always one for a good argument. I think all of us are. That's why we're here. We're lawyers, right? We like to argue. We like to take up contrary positions and try and get our point across and prevail. It's in our DNA. So I'm really looking forward to that. As it is, as a practicing patent attorney, I do that a lot, but only when I file applications in other countries, because South Africa does not examine patent applications. They're only examined formally to make sure that the right forms are on file, that they've been signed, that the fee is being paid, that kind of thing. Nobody actually reads the specification. And but of course, the Americans, the Chinese, the Japanese, the Australians, the Europeans, they all substantively examine their patents, and I argue with them all the time. And it's great, because when you win, or when you prevail, or you compromise to get to your position, which is by far the most common position, is compromise. Then you feel you've added value, and you sort of got the argument done. So, and there's a lot of psychology which goes into arguing with an examiner. Nobody wants to lose face, so you give a bit of ground, he gives a bit of ground, etc., etc. And it's a very interesting aspect of the job. So, and if you ever become a trademark attorney, as you guys are more likely to be, because unfortunately you need a chemical, or engineering or science background to be a patent attorney. You guys will be trademark attorneys, and there's plenty of scope for argument about trademarks as well. Whether something is, gives rise to confusion or that kind of thing. So, that lies in wait for you if you choose a career in IP. So, just to go back, to be a patent attorney is I would say it's quite difficult. There's quite a high barrier of entry to the profession, because we deal with the technical aspects of intellectual property. We deal with technical solutions, be they chemistry or electrical engineering, or civil engineering, or how to put up a building, how to make a better chemical compound, pharmaceutical, a better paint, a new way of making steel. And let's not forget about genetically modified organisms and DNA and all of that stuff. So obviously you need a background in that. So between myself and my partners, we cover all disciplines. I myself have a degree in chemistry and biochemistry. That was my undergraduate degree, and then I went on to do my law, because obviously you need a law degree, right? And then you have to be a normal attorney, just like everybody else. So you have to write your bar exam, Maj Court, and accounts and all of that. Even though to this day I've never been inside a magistrate's court in my life, I wouldn't really know what to do there. I had to write the exam and obviously pass the exam to be an admitted attorney. And then waiting for you, if that's not enough, waiting for you on the other side, and some of you may have had some exposure to these, is what's called the SIPL exam. So All the patent attorneys, all the trademark attorneys in South Africa are members of an institute called the South African the South African Institute for Intellectual Property Practitioners. I can't remember. It's SAIPPL, SAIPL, South African Institute for Intellectual Property Practitioners. I don't know. Anyway, it's called SAIPL. They have a separate set of exams for you on the other side, waiting for you on the other side, and they are very difficult exams, right? I mean, when you pass your SAIPL exams, you can really pat yourself on the back because the standard is very high, and you have to pass the trademark exams, call yourself a trademark attorney, and you have to pass the patent exams to call yourself a patent attorney. So trademark attorney and patent attorney are protected titles. You can't actually call yourself a patent attorney unless and until you've passed these institute exams, and they are tough because they are lectured by and examined by members of the profession. All different attorneys and different law firms get together, they lecture the course, they set the exams, they mark the exams, they moderate the exams, and they don't let anybody in who does not come up to the required standard. So if you are looking for a career in this, and I cannot recommend a career in IP highly enough. It is just the most fantastic area of law to practice in because it is so interesting. But if you choose this as a career, it's you've got a lot of work ahead of you from where you are now. But trust me, it is totally worth it. I would not hesitate to recommend it because, like I said earlier, every day is different, and you are dealing by definition with human ingenuity, right? They're making up marks, they're writing poems, they're writing songs, they're creating stuff. They're giving us stuff that didn't exist before this inventor, songwriter, marketeer came along. And it's really a privilege to work with these guys and to work on the cusp of human knowledge. They're advancing the platform, the intellectual platform on which we stand, and we are there protecting that border as IP professionals. And it's a very cool place to be. It never gets boring. No day is the same. You have to be on your toes all the time because you're dealing with very clever, very creative people. And you have to be able to keep up with them, and that's very cool. So that's all about what patent law is about, and intellectual property in general. So just to return to patents. So patents are sort of technical in nature. So patents protect how something works, right? So it would be a method of making a pharmaceutical or a particular mechanical contraption, be it a braai, be it a carburetor for a car, be it a mechanical chessboard or whatever. So you have it's technical in nature, and that's why you need the technical background, because don't come to me with a patent about the electronics in a mobile phone. I'll be completely lost. But I can really help a lot when it comes to a new chemical compound or a active pharmaceutical ingredient or a genetic invention. I understand how DNA works, etc., etc. And if you were to give this to my electrical engineer partners, they would just, be sitting there slack-jawed. They don't know. So they know their stuff. I know my stuff. And to the extent we don't really mix substantively. We all know how the Patent Act works, but being a patent attorney is a blend of technology and law. So that's how we sort of do it. And so as I say, great occupation, great vocation, but it takes a while to get there. Very rare to be a patent attorney under 30 because there's just so much studying that goes along with it. But trust me, when you make it, your life will never be the same again. It's very, very cool. And we work with our peers all around the world. So and we travel a lot. We travel on business. We go and see how factories work. We go and see how mines work. Well, we did before COVID. It's coming back now. We go to conferences all around the world. As I say, we file applications all around the world. So I send them instructions, and then in turn they send me instructions, on a reciprocal basis. And so it's really cool. You make a lot of friends around the world. I know people in so many of the major cities around the world just because I've worked with them. So it's a real privilege to be in this sphere. And there's a lot of mutual respect because we all know just how hard we worked to get there. And so, as I say, big hill to climb, but totally worth it when you get to the top. Okay, so let's focus on patents now. And so we said that we work under the 1978 Patents Act. It's been in force all these years, and it's going rather well. And I mentioned the British Patents Act. And so that sort of suggests, yeah, hi, Sally.
Hi, Prof. You said, just a minute, South Africa does not examine the patents application, right?
Mm-hmm, mm-hmm.
And you said you normally, I don't know, do your applications all over the world, something like that.
Mm-hmm, mm-hmm.
So now my question is, how do you do with the issue of jurisdiction?
Okay, so that's a great question, Sally, and that's exactly what I was coming to now, which is to say that patents are territorial in nature, which is to say that because it's a right which is granted by a government, a South African patent only extends to the geographical area of South Africa and its territorial waters, because it's a right given by the South Africans. So the Zimbabwean government I can't give you rights to Zimbabwe, and Zimbabwe can't give me rights for South Africa, right? So if you want a patent application in South Africa, you file it in South Africa, and you deal with the South African authorities, and then you get your patent here in South Africa, and that's it. If you want a patent in America, then you have to take that application and you have to file it in America with the American Patent Office. And the same is true for Europe, Australia, China, Japan, Brazil, all the countries around the world. If you want a patent in that country, you have to file it in that country, and you have to deal with that country's patent legislation and patent office and the patent attorneys in that country. So it becomes a very expensive business because, my American buddies, they are charging $650 an hour to read my correspondence and file the application for me, receive the papers back from the USPTO, and then send them on to me. So, it's very, very expensive. And, with the Rand fluctuating and getting generally weaker over time, it gets more and more expensive. So this is how it works. So jurisdictionally, we're okay in terms of, we've got a South African patent, and that's it. So when you don't have rights in South Africa unless you've got a granted South African patent. The issue with jurisdiction really comes with sort of mobile app applications and the cloud and all of that thing, because if you're infringing a technical sort of app type patent, who has jurisdiction? Because you're on your phone here in Joburg, you're communicating with a server in Pretoria. That server is talking to the cloud, which may be based in a data center in Iceland, but the app was written in China. It's just a nightmare. Just a nightmare. Don't ask me to answer that question, but I think you'd have to solve that kind of jurisdictional problem here in, sort of on a case-by-case basis. I mean, if you're infringing the app here in South Africa, the act of infringement happened here. That's probably where you would be looking to institute action and look for relief. So you'd have to solve that kind of jurisdictional question from first principles, I suggest. But that's the tricky thing. But otherwise, for a pharmaceutical or something like that, it's straight up no rights if you don't file in South Africa. And so what tends to happen is that there'll be like global infringement. A Chinese manufacturer will manufacture and then export into South Africa and Australia and Europe, and so they fight these battles in all these different countries. And what often happens is they will choose a country to fight in, South Africa or Australia, and then when they win, they say, listen, we won in Australia, there's no reason we're not going to win in South Africa, Europe, etc. And then they force the other party to sort of come to the table to make some provisions, because they know that they will be beaten around the world. So they'll often choose a battleground, an arena, and then take it from there. It used to be South Africa, because a lot of patent battles were fought here because we've got a very robust legal system, and the courts were really good, and judgments were handed down quickly. And, we've got a law which is very similar to the UK, etc., etc. But I think that's gone off the boil recently. I think they feel that IP skills have been lost somewhat from the judiciary, and that judgments can take a long time to get handed down. I mean, we can wait 2 years for a judgment here if it's tricky. And of course, that's just simply not acceptable in the international arena. So litigation in South Africa has definitely gone down. Interestingly, patents, let's just talk about this quickly. When it comes to litigation, it's High Court, right? But there is a special court to hear patent matters called the Court of the Commission of Patents. And really what it is, it's just a single bench of the High Court. And another reason, we used to have dedicated technical judges who sat as commissioners of the High Court, of the Court of the Commission of Patents. And basically they're a High Court judge, and then the judge president says, "Oi, you're going to sit in that court, you're going to hear this matter." And he used to pick from a small pool of judges who had IP experience, and sometimes they had technical backgrounds, and they were really good in because they understood patent law, not only the actual act, but also because on an inherent philosophical level, they got it. But that practice seems to have gone by the wayside over the years. And so now they just go, off you go, court. And it's like, but, I do divorces or I do criminal. Now I've got to like read the Patents Act, understand it, listen to these, these hectic arguments from senior counsel, understand the technology, and then give a reasoned judgment. And that can be tricky. So, I'm not too sure if that practice will be reversed, but that's currently the practice, is that you get it when you get it, and there's no particular judges. But so the court of first instance to hear a patent infringement matter or a patent revocation matter is the Court of the Commission of Patents, which is de facto a high court. And then from there you can appeal to a full bench of the High Court. And from there you can appeal to the Supreme Court of Appeal in Bloemfontein, which is where most of them actually go. And then from there, you can obviously go to the Apex Court, the Constitutional Court. And there have been 1 or 2 patent matters which have been heard there, but we'll discuss them later in the course. But really, nothing too much. I mean, the whole intellectual property framework is considered to be compliant with our brilliant constitution. The right to property, etc., etc. So there's no conflict there. It all fits nicely together. It's just, a few things here and there about whether this little right has been infringed or that little right has been infringed. So that's generally how it works. So matters are always heard first in the Court of the Commission of Patents. Then by agreement, the parties usually skip the full bench and go straight to the SCA. So they're normally heard in the Court of Commissioner, and then they go to the SCA. And then the SCA is, the one that prevails, that judgment. And there are a couple of cases which haven't gone, are not appealed, and we are stuck with judgments that I just know in my heart of hearts are wrong. The judge got it wrong, but for whatever reason, the parties chose not to appeal. And I'll tell you when we come across these judgments, because there's a few. There's Bone, which talks about the 3-month window to advertise acceptance, which we'll talk about in the next lecture. And then there's another one which talks about 69A, section 69A. And again, we'll talk about that in the fullness of time. And in my humble opinion, they are wrong. But we have them because they were handed down and just not appealed for whatever reason. The parties might have run out of money. The parties might have got what they wanted ultimately. And these interpretations of sections were neither here nor there according to the judgment, but they are what they are. So on that basis, it's a less than perfect system. There are judgments out there which I think, could be better, but it is what it is, and we play in this field. But of course, if you've got a commissioner judgment and you think it's wrong, you can do what you think is right, and then if somebody comes at you, you can take it. You can't obviously take the original judgment on appeal, but you can argue your case and argue that a particular judgment is wrong and take it to the SCA. I mean, that's always, an option in these things, but I don't think anybody really wants to. There's not a lot of appetite for that. So we have these flies in the ointment that we've kind of inherited over the years. And I'll tell you when we come across them. There's a few. I mean, there's not a lot, but there's a few. So, yeah. So that's, I don't know how we got onto that topic, but it was about the territorial nature of patents and how they are country to country. Okay. I mentioned, so we've got all these patent law, we've got the British Patents Act, we've got the European Patent Convention, we've got the US Act. So the US Trademark Patent Office is called the USPTO, United States Patent and Trademark Office. We are just called the South African Patents Office, or CIPSI, the Commission for Intellectual Companies and Intellectual Property Commission. The British Patent Office is called UKIPO, United Kingdom Intellectual Property Office. The European Patent Office is called the EPO, the European Patent Office, and so it goes. So, everybody, the Chinese Patent Office is called SIPO, Chinese Intellectual Property Office. Australian Patent Office, Japanese JPO, Japanese Patent Office. So, they're all of these different names, and they all act under their particular legislation. But the legislation is largely harmonized from all the countries around the world, because there are a number of international treaties and conventions to which South Africa and most of the countries around the world are signatories to. And the most important of these is the Paris Convention, which really sort of came about, I don't know, a long time ago, sort of in the 40s, I think. And this was the first one which really tried to get some harmonization together. And the Paris Convention is important because it sort of sets out the basics, what it has to say, the minimum. But the one thing the Paris Convention is very important for is because it says that it establishes a priority period, right, of 12 months. And that is called the convention period because it's named after the Paris Convention. And basically what it says is that if you file a patent application in South Africa today on the 5th of March 2022, then that starts the clock ticking, and you have a 12-month period to then file your application in any of the other Paris Convention countries. And you need to do that on or before the 5th of March 2023. So you have a 12-month convention period. And if you do it within that period, your South African filing date, the 5th of March 2022, will be considered your priority date, the first date of application describing that invention, and that is the date by which novelty and inventor's step are judged. So it's a really important aspect. It's called the Convention Priority Period, 12 months, and it was established by the Paris Convention. Now, there are other conventions which South Africa is a party to, and we will explore these in more detail over the course of the lectures. But probably the next most important one, it came in I think 97 or somewhere 95. It's called the Trade-Related Aspects of Intellectual Property Law, or TRIPS. And that's set about really taking harmonization to the next level. So all countries around the world then really got to harmonize a lot more. So, for example, Paris didn't say how long the term of a patent had to be. But most countries around the world just took it as accepting of 20 years from the date of filing at the patent office. Okay, 20 years. But the Americans had a different idea. They said, no, 17 from the date of grant. Okay, so that was different because, sometimes it took longer than 3 years for the patent to be granted. So you kind of had a longer period of protection. So it wasn't harmonized at all. TRIPS put an end to all of that. They said 20 years from the date it's filed, no matter when it's granted. If it takes 1 year to grant or 5 years to grant, the term is the same from the date of filing. So the Americans, sort of had to grudgingly accept it. And there were other things as well, like mainly related to methods of treatment and pharmaceutical patents, which we will explore in greater detail. So that was the TRIPS. Now, that everybody started reading TRIPS when we started talking about the COVID vaccines and the patents and the intellectual property behind the COVID vaccines, and whether we should be waiving patent rights and things like that. So that became a really hot argument. And that sort of featured quite heavily in the last 2 courses, but I think that boat has sailed. So I'm not going to be setting any questions on the COVID vaccine waiver. I think it is what it is. There's some excellent papers. I'll put them up on Blackboard. You can read about them. As you might imagine, as a patent attorney, I do not favor patent waiver. I think there are sufficient checks and balances already built into the Act, which we will explore. And, the fact of the matter is that TRIPS in particular gives governments huge flexibilities to waive patents or to acquire them as along expropriation lines. Just like, a government can expropriate property if they're building a highway or something like that. They can expropriate patents in times of need. And, the governments chose not to do that. So, if you've got, on the one hand, that you've got this flexibility that you can just expropriate a patent if you need it. And then on the other hand, they say, no, we should just waive patent rights in their entirety. It doesn't really make a lot of sense on a sort of logical level, because you've got the arsenal, you've got the weaponry to just take what you need. You don't have to waive the whole system. You don't have to throw the baby out with the bathwater. So it's a very interesting concept. Also, you've got to look at it from a technical point of view, because patents are just one aspect of rolling out a drug. You've got all the know-how behind building up. You've got highly complex manufacturing, distribution, cold chains. You've got the dossiers which are required for registration in a particular country, by the Medicines Control Council. You've got to prove it's safe. You've got to prove it's efficacious. You've got to prove its half-life in the bloodstream, how many rats did it kill, etc., etc. All of that data is highly confidential. It exists in the 5th species of intellectual property, mainly trade secrets, confidential information, know-how. And so by waiving patents, you're not waiving the rights to confidential information. So you're only sort of getting half of it right. So, between TRIPS made provision for governments to acquire patents as they wish, and it also set out a lot of a framework regarding what's called compulsory licenses, whereby if I hold a patent, but you are of the view that I am misusing my patent in the sense that I'm holding it back from society on purpose because I'm abusing the rights that I have, you can approach the court for a compulsory license, and the court can say, yeah, John, you're not being cool with how you're managing your patent. And so, Rudo, you get a compulsory license, and, you have to pay John, I don't know, 5 cents for every widget that you make. But, I'm prescribing that you have access to this patent. So this is also, a major route, a major flexibility offered in the event where you really need access to technology, and for whatever reason, the patent holder is not allowing it. So there are many sort of checks and balances built into the Act. As I say, I'm a big fan of the Act. It's highly iterated. It's a good Act. Is there room for improvement? Absolutely. That's what the white paper, the intellectual property policy, is about. But right now, there's a lot in there, and it's fit for purpose as it currently stands. So, and that is because of these conventions, right, and the trade-related aspects of intellectual property. TRIPS was a big one. It did cause the local act to be amended, and now we're TRIPS compliant, and I think it's good. And sort of all patents acts around the world, or most patent acts of the different countries, are aligned with TRIPS. Another convention that we will talk about in the fullness of time is the Patent Cooperation Treaty. And this is a massive treaty around the world. There's like 140 countries are signatories to it. And what that basically says is that it facilitates filing in those countries. So this is something that's actually run, it's a treaty or convention, patent convention treaty, patent cooperation treaty, which is run through a branch of the United Nations in Geneva. And there's something called the World Intellectual Property Organization, WIPO, and they're a branch of the UN, and they sort of administer this treaty. And what it basically says is, if you sign up to this treaty, you first file your first application in South Africa, And then, like I said earlier, under the Paris Convention, you then have to file in Japan and Europe and Australia and the US, wherever you want it within 12 months. The differences with this is under the Patent Cooperation Treaty, you just file one application with the treaty, and then you have all of these rights which are pending around the world. So you still have the right to file in the US, you still have the right to file in Japan, but you filed your priority application, and within a year you filed your PCT application, just one application, and then that keeps your rights going around the world. And then what they do then is then they will look at your application, they will centrally examine it by WIPO, and they'll say, yeah, you don't have a hope in hell, or no, this looks good, you can get some rights, you might have to nip and tuck here and there, but for the most part you're good to go. And then you can make an informed decision about whether you want to file into all these countries, and that's called entering the national phase of the PCT. And then because you're in possession of the search report and examination report of your application, you can then make an informed decision about whether it's worth it to pay the money to file in the US and Japan, etc. Because on the basis of this initial report, it looks good that you're probably that it is patentable and that you will get your invention. So that's pretty cool. And it's a very, very popular mechanism to file around the world. I would say of the applications which are filed in South Africa from, all the different countries around the world, I'd say like 97% of them are PCT, and a very small percentage of them are convention. So which are the ones where you just file in South Africa 12 months after and you ignore the PCT. So PCT is huge. It started, I think, in the mid-90s. South Africa was late to the party. We signed up in March 1999, but we've been rocking roses since then. It's a big part of our practice here. And we had to amend the acts and build in all these chapters, but it was cool because the wording of everything needed to be, we just sort of got it from WIPO. They said, here's the wording that you need for your act. I'm seeing two Rudos. That's weird. Rudo Guest and Rudo Koseke, also a guest. Okay. We're still waiting for Danae, but hopefully, yeah. Rudo, are you there?
Yes.
Okay.
Sorry, I'm just connected with my second device.
Right. Okay. Cool. All of you can hear me, okay? Hey, you're all getting what I'm talking about, yeah. Good.
Yes.
Awesome. Okay. So, so the Paris Convention and the trade-related aspects of intellectual property set the scene for harmonization, and so that's why the PCT kind of works, because you can expect the same treatment in all the different offices around the world, and you can have a single sort of patent application. So let's just talk about that. In the presentation that I uploaded onto Blackboard, you've seen that I kind of spoke about how a patent application is put together, and they're built around a skeleton or a precedent, and they're all kind of like the same, and they are all focused on providing a solution to a problem, patent specifications. So how they tend to work is they'll say, they give a brief introduction. This invention relates to a manner in which sugar is purified. And then they'll go into a bit of a description about how they presently purify sugar and how the disadvantages that currently are problematic. So, it uses a lot of energy, or takes a long time, or it's very messy. They'll just talk about those. And then they'll say, this invention seeks to sort of ameliorate those problems. And the way we do it is we change the process by doing this. And so then they say, okay, so then you only heat the water to 60 degrees or whatever. Whereas previously you had to heat it to 90 degrees. And then, so if that's your invention, and then you go into a description of how the invention works, and all the different like embodiments of the invention and the slight changes and the slight tweaks you could make to the invention, still keeping to the inventive concept. And then you have like a whole bunch of examples where you prove that it works. You say, you know, we did this process and we heated it to 90 degrees and there was this much waste and it took this long. And then we did the same process, but according to the invention, only heating it to 60 degrees, it took half as long and the waste products were 1/3. So you can see the technical advantage which is associated with the invention, and the invention is to only heat the water to 60 degrees. And so, you know, you demonstrate that it works, you demonstrate the advantages of your invention, and those are set out in the examples. And then every patent application ends with what's called a set of claims. And the claims are by far the most important part of a patent application, because they distinctly set out in one sentence what the invention is. And they define the ambit of the monopoly, right? So, and I'll go into this in great detail during this course, but the claims define the invention, and they basically set out what you're allowed to do and what you're not allowed to do. And then so, you know, the claim would be a process for purifying sugar wherein the molasses is not heated to above 75 degrees. And then claim 2 would be a process as claim 1, wherein the molasses is not heated to more than 70 degrees. So, you know, it's like onion skin. It's your broadest one there, and then you focus down onto eventually you say where the water is heated to 60 degrees. And so these claims come down like that. And the novelty and the inventive step of an invention are judged against the claims. The description, the examples, the contextualization, which you've all put previously, are there just to present the claims. And once you've got the claims, they're the ones by which novelty and inventive step are judged. So so let me come back now to what I said earlier, which is all about the you know, the terms and conditions which apply to getting a patent. And these are very simple. So there are 3 basic requirements for patentability of an invention. First of all, the invention must be absolutely new. It must never have been disclosed in the history of humanity, and we will discuss this in detail now. Secondly, it must be inventive, which is another way of saying it can't be obvious. Can't be just an obvious little change compared to what's gone before. And again, we'll discuss this in detail. And it must be capable of being used in trade, industry, or agriculture. So that's, I think most things are being capable of being used in trade, industry, or agriculture. You just need to sell it or use it, and you're good, you know. But things like scientific theories and that kind of thing aren't capable of being used in trade, industry, or agriculture. So they are excluded from patentability on that basis. There are a couple of other exclusions from patentability. It must work. Okay, sounds obvious, but you know, if it doesn't work, you can't. It's not patentable. So, you know, you can't have a patent for a pencil adapted to fly to the moon, because you can't teach that, right? I mean, because nobody can get that to work. So it's got to have utility, as they say. And then it can't be against natural law. So you can't patent a perpetual motion machine, because the laws of physics dictate that that's impossible. So you're obviously not going to patent that. And trust me, as a patent attorney, you will have dealt with dozens of these, you know, perpetual motion machines. And the guy will come and put this apparatus on the desk in front of you and say, look, that wheel has been turning for 2 weeks. And, you know, it's obviously perpetual motion. And you've got to say, yeah, but, you know, it might turn for 2 years. It will slow down eventually. It'll wear out, you know, or whatever. So the friction might be minuscule, but it's still there. It's slowing, it's sucking energy out of that thing. So, you know, you've got to be quite politic in how you handle it. But well-established laws, nah, not going to happen. And then the other one that you can't get a patent for is stuff which is what they call contra bono mores, against the good value of society. So this doesn't mean that You know, they're not sort of like the Mother Grundys or you know, they're looking to say, you know, that's of an adult nature. You can't get a patent for it. Trust me, that they're not the moral guardians like that. They don't care about what goes on between consenting adults behind closed doors. All likes of mechanical contraptions and everything, that's absolutely fine to patent. What they don't like is stuff which is not for the good of society. And what we're talking about here are things like instruments of torture, letter bombs, and things like that. Anti-personnel mines, dum-dum bullets, just the horrible things, you know, things designed to hurt people or that have no good to society. That you can't get patent protection for that kind of nasty stuff. And when you think about it, that's pretty cool. It goes to the central tenet of patent law, the central philosophy, which is we're here to solve society's problems. And so we encourage you to contribute proper solutions. I don't want a more efficient way to kill someone, but I do want a better drug to treat HIV or COVID or whatever. You know, I want to improve society. I don't want to drag it back to the dark ages. So stuff like that is not patentable. But you know, if it's capable of use in trade, industry, and agriculture, it's not designed to kill anybody. Then you know you're on the roll. So so then this brings us to the question: well, within that framework, what is an invention? Because patents protect inventions, right? And I've always said, well, an invention is a solution to a problem that's new and inventive. Okay, cool. We can use that as a starting off point. But the Act doesn't actually ever really define an invention. It just tells you what's not an invention. And so in terms of Section 25, okay, so Section 25 of the Act is the heart of the Act, okay? Up until then, it's all been about like how to be a patent attorney and, you know, what you've got to do and all good things like that, how the registrar works. 25, boom, here we're talking about patent law. It defines novelty, it defines inventive step, talks about methods of treatment, and it talks about what is not an invention. And Section 25(2) is the one that says the following are not inventions. And so these things in no way, shape, or form can be the subject of a patent application. And these are discoveries. I'll talk about each of these in detail. Discoveries, scientific theories, mathematical methods, literary, dramatic, musical, or artistic works, schemes, rules, methods of performing mental acts, playing games, doing business, computer programs, and presentation of information. Okay. And then later in Section 25, we talk about methods of treatment, and I'll come back to those. But these ones which are specifically excluded, certain things that are specifically excluded from being considered inventions. And as such, an invention can be anything which does not fall within these exclusions. Okay, so the one that I find the most interesting is discoveries, right? Because, you know, what's the difference between a discovery and a creation? And when you think about it, it's quite simple at its core, and that is that a discovery is something that has always been there, and you just stumble upon it. So a good example of you discover dinosaur bones, okay, because you know they've always been there for millions of years, and one day you're just crawling through the desert with your toothbrush, and you know, voila, you uncover the fossilized skeleton of a Tyrannosaurus. Great for you. You haven't created that, you just found it, okay? And that's what a discovery is. And that's the difference between a discovery and a creation. So when we just sort of modernize that concept, you know, we've always had DNA in us, right? And so when Watson and Crick discovered the shape or the formation of DNA, and in particular the double helix, that's not patentable, right? Because it's always been there. They were just a couple of clever guys who figured out, you know, how the molecules fit together and how you get this double helix ladder chain kind of thing. Incidentally, Watson and Crick were the guys who got all of the fame for that, but there was a woman, I forget her name, which is just goes to show how terrible this is, who they couldn't have done it without. but because of the patriarchy in place at that time, she was excluded from the Nobel Prize. Subsequently, she's been elevated. She's part of the team. It's Watson Crick and this lady. She was a doctor who did crystallography. She took sort of pictures of these things, but it just looked like a series of dots. Nobody could figure out what they were. But without that picture that this doctor took, Watson and Crick would never been able to figure out how it all fitted together. So that's just an aside, that the world has come a long way. We've got a long way to go, but we are making progress. In this day and age, her contribution would never have been ignored like it was. Anyway, that's just an aside. So Watson and Crick and this lady discovered the structure of DNA. Okay, no patents. But now, when you start talking about, okay, so that's how DNA fits together. So now I'm going to take it apart and I'm going to build it again, but I'm going to build it, I'm going to manipulate its structure. I'm going to build it how I want it. That's called recombinant DNA. And that is a creation, okay? Because that is the application of human ingenuity. I've got the basic building blocks, which were discovered, but now I'm actually going to create something off the back of that. That's creativity. That's patentable. The structure of DNA per se, as it exists in nature, that's not patentable because that's always been there. So that's an interesting. That's basically the difference between discoveries and creativity. So that sort of segues straight into the next one, which is scientific theory. So what they're really talking about here is, Einstein's theory of relativity or Newton's laws of motion or gravity or whatever. These are theories. They are accepted to be true, but they're not patentable per se. So I had a case once where a scientist of mine had figured out how he felt. He had a theory about how he felt water molecules packed together in the fluid, in the flowable fluid or the water, which we all know and love. And he felt that there was a different way in which the H2O molecules sort of packed together. And it was a great theory, and it really did, it had legs, So we put together a patent application for it and we put it in, and it was refused by the Patent Office, the UK Intellectual Property Office at that time, because they said it was a theory, so it was excluded from patentability under this 25(2). But also, it as a theory, it didn't have application in trade, industry, or agriculture, which is an exclusion from earlier, right? Being one of the three: novelty, inventor step, usefulness. So it wasn't useful per se. So it was excluded on those two grounds. I wrote back to the Patent Office and I said, well, it's very useful because we can figure out, we can use it to predict how quickly something dissolves. Solvation properties, based on the chemical structure of a compound and how it'll fit in with the water molecules and everything. And the Patent Office came straight back and said, oh, we agree. It is useful, but you didn't claim a method of predicting how quickly something will dissolve. If you had claimed that, that's absolutely patentable. But you claimed how water molecules, or how you think water molecules pack together, that's not patentable. But using that knowledge to predict how quickly something will dissolve in water, that's patentable. So that was an interesting lesson for me early on, is the difference between, the practical application and the concept of a theory, or the concept of usefulness, because everything kind of it's all part of the same analysis. So that's a scientific theory, that's usefulness. Mathematical methods, again, these are not patentable. So I know, as lawyers, we probably haven't done maths since we wrote our matric all those years ago. And I'm sure, like for me, it was a bit of a traumatic experience writing matric maths. But if you remember, all of those are, calculus. I think you guys would have done calculus. I only did it by the time I got to university. I'm still traumatized, but I see my kids did calculus in matric. So yeah, calculus. But even if you go back to the theory of Pythagoras and right angle triangles and things like that, those are all mathematical methods, right? Not patentable, thank goodness. We don't have to do any of that. So where you left it, that's where we leave it. literary, dramatic, musical, artistic works. Well, I mean, obviously that's slap bang copyright, and you guys have done copyright. I think you did it last year with Prof. Alberts, so you understand, right? That's not patentable. I mean, no technical effect, so it's pretty clear on the face of it. Schemes, rules, methods of performing mental acts, playing games, or doing business. Yeah, this one is quite sort of clear on the face of it. So the rules of monopoly, you know, you're not going to get a patent for that. The rules of playing any game, you know, Who Wants to Be a Millionaire, or Tipping Point, or Pointless, or any of these game shows that you see on TV at the moment, they're not patentable. But to the extent that you need apparatus to practice that, to put the game into play, then sure, that might be patentable. I don't know if you guys have ever seen this program. I think it's on BBC, on DSTV. It's called Tipping Point. It's got a machine. These discs fall down, and then they fall on a tray, and then there's a moving thing that pushes the discs off. And if the discs tip over the edge of the step, then that's what you get. That's what you win. That apparatus, it's well known, but you know, in its day, it would have been patentable. Although the concept of the game is not patentable, the apparatus needed to put it into effect can be patentable if it's new and inventive. So that's a distinction to make. And then the last one is computer programs, and this is code, right? It's just software, so it's protected under the Copyright Act as well, you know. But I do want to talk about, and then the last one is presentation of information. That's a PowerPoint, man. Come on. You're not going to get a patent for that. Or maybe instructions for use, or you know, like the packaging insert when you buy your Disprin, and it's got that little insert saying don't take too many of these or whatever. That's not patentable. That's just presentation of information. You're not going to get anything out of that. So, you know, those are the last ones. I just want to go back and talk about methods of doing business and computer programs. So Section 25 of the Act immediately goes on to say, yeah, we might have excluded, you know, those 7 or 8 things as inventions, but they're only excluded to the point that they are not inventions, that they're that per se. So our courts will probably follow the European way of doing things, which says that if there's a technical effect, if a patent describes the use of subject matter from one of the specifically excluded categories in order to obtain a specific technical effect, then patents may be obtained. So if it's possible to write software for a technical effect, it's probably you might get a patent for that. So I'm trying to think of a good example, and I really sort of battled. The one I can really remember, and you guys are probably too young to remember this, but Amazon, when it originally came out, had something called One Click, whereby if you saw something you liked, and you were registered and you were signed in to the website, you could just say buy it with one click, and you just click this one button, and then like it pulled in all your information and your credit card and everything, and you'd bought it. You didn't have to go through all those multiple screens that are there now, like on Takealot, where you say, how do you want it delivered? And all of that was preloaded, and just this one button, buy it now with one click, and you could buy it. So that was a technical effect, because the effect was that you didn't have to go through these multiple screens. It was all preloaded onto this one button. And if you wanted to change method of delivery or something, you had to go through all these screens. But if you were happy with how you'd set the system up, you could just click this and then it would happen. That's a technical effect. So the software that gave rise to that could, in fact, be patentable. And so, you know, that is an exception to the software not being patentable rule. And then, you know, there might be other methods of doing business, which might be patentable if there was an effect. And don't ask me to think of an example, but I'm just saying that global debate seems to suggest that it's only not patentable to the extent that it is something per se, rather than, you know, moving beyond that and giving you a solution to a problem. So those are sort of like what's not patentable. I just want to talk about plant breeders' rights now, because these are the next things which are important. So another exclusion from patentability is an essentially biological process. So the Act makes a distinction between a biological process and a microbiological process. Okay, so what they mean by a biological process is selective breeding. Okay, so it would be by selecting, different plants to come together to breed, or by grafting branches of trees onto each other, something like that. Selective breeding, so it says here, methods of crossing, interbreeding, selectively breeding plants or animals merely by selecting for breeding purposes or bringing together the specific plants or animals having the certain desired characteristics. That's not patentable. Okay, so you know how they breed dogs to get a pug or to get a whatever, you want a dog with a longer tail, so you select two dogs with long tails and you get them to mate, and then the puppies will have long tails and whatever. That's not patentable. And to the extent you can do that with plants, when you selectively breed a plant, you get a plant breeder's right for that. Okay, so what we're not talking about manipulation of the genes, of the genetic material, of the DNA. That is a microbiological process, because you're working like on a microscopic level, and that's genetically modified organisms, etc., etc. That is 100% patentable. Okay, we've got loads of patents on genetically modified wheat, genetically modified tomatoes, little bacteria that are genetically modified to make insulin and things like that, totally patentable. But when you select different varieties and put them together and get them to breed as nature intended, that lies outside patentability. Okay, and so that is what plant breeders' rights are for. So that's how you get waterless or seedless watermelons, okay, or seedless grapes. You see within your variety, this particular one had very small seeds or no seeds, as well did this one. You put it together and then suddenly there's no seeds. That's very valuable, right? Because consumers don't like spitting out pips from their grapes, don't like having watermelon seeds. And so you can see that most watermelons we buy these days don't have seeds, or oranges, grapes don't have seeds. It's because somebody somewhere has selectively bred this variety, and now they can get it to go continually, and they make and sell that, and consumers prefer it. And of course, that is what makes money, right? Because consumers like it that way. So from that point of view, you can see how, because it's an essentially nature as nature intended, it's just manipulated in terms of what you're putting together. It's not patentable, but there is an avenue to nonetheless protect it, being plant breeders' rights. When you start manipulating organisms, be it animals or whatever, on a genetic level, that is patentable, because that is full-on technical creation. So again, it goes to the sort of central core of these things, right? This is how it was intended to work. Okay. What I want to talk about now is under section 2511, there's a very important exclusion from patentability as well. And that is methods of treatment of both humans and animals. So it says, an invention of a method of treatment of the human or animal body by surgery or by therapy, or of diagnosis practiced on the human or animal body, is not capable of being used or applied in trade, in industry, or agriculture, and therefore it falls outside of patentability. So what are we talking about here? We're not talking about the drug. We're not talking about the scalpel or the MRI machine, or any of the instruments that are used to treat animals or humans, or any of the chemicals or the solutions or the cells or the actual pills that we take. No, that's all patentable, right? What we're talking about is how you treat people. And the reason behind this is that the person who would infringe that patent would be the doctor or would be the vet, because they're the ones who practice the method of treatment, right? And South African legislation has said, we're not suing doctors, we're not suing vets for simply treating people, okay? For making people better. That doesn't work for us. Of course, the Americans don't have such scruples. Methods of treatment are protectable in America. So you can sue a doctor for patent infringement in America, but you cannot sue a doctor for patent infringement in South Africa. And I think that's right. And I think this is just one of many examples why the legislation is so beautifully iterated, because, you know, I think that's correct. So, you know, that you will try and get patents for saying, you know, a method of treating insomnia, the method including the step of applying this at 2 hours before you go to bed, and then applying that when you go to bed, and then sleep will improve. That's not patentable. That's a method of treatment. But what is patentable is the drug that you will take, or, you know, the little thing that you put on your nose to stop you snoring, or to stop sleep apnea, or something like that. So that's an important distinction about that. So we don't sue doctors. Methods of treatment per se are not protectable. I want to move now on to the because I always find this interesting, and that is the treatment, the protection of pharmaceuticals, and how the claims, which I mentioned earlier, are so important, how they are framed. Okay, so I actually want to talk about a drug called thalidomide. Now, I don't know if you guys have ever heard of thalidomide. You should check it out on Wikipedia. But it actually was first created and invented and protected by way of a patent in the sort of early 60s. And what it was supposed to do was it was supposed to stop morning sickness in pregnant women, because morning sickness is very unpleasant. I saw my wife had it with both of our kids when she was pregnant, and it's very debilitating. So the concept of taking a pill and, you know, not being morning sick, well, that was, you know, that was quite popular at the time. Unfortunately, and this was very unfortunate, the drug is what they call teratogenic, which means to say that in a very small instance, it deforms the fetus. It deformed the developing fetus. And so there is a whole generation of babies that were born called thalidomide babies, and they didn't have, or their limbs were incorrectly formed. So everything else was fine. They are fully mentally there, but they just don't have arms, or, you know, their arms are not properly formed. And so this was very sad at the time. And there was a lot of introspection, and the drug was quickly pulled when this was discovered. And so thalidomide as a drug just sat on sidelines on the shelves for a long time, because you know, obviously nobody wanted to take it. And its original purpose, being the treatment of morning sickness, was, you know, that was it. Then, about 30 or 40 years later, they came back and they re-looked at thalidomide, and they realized that actually thalidomide is really good at treating leprosy, you know, which is a terrible disease. And so they repatented it for the treatment of leprosy, right? And so not many people who suffer from leprosy are pregnant. So that worked out well, given that thalidomide is so dangerous for pregnant people. But given that most lepers are not pregnant, it was fine. And it was really good for treating leprosy. So what they did was, when they originally protected thalidomide by way of patent, they said a chemical compound of the following formula, you know, like a benzene ring and a nitrogen and oxygen, whatever. They just described all of that. And then they said, and that's thalidomide, and it's that we protect. That patent has long since expired because of the 20-year life. And that was the first use of that compound, right? Was treatment of morning sickness, use of thalidomide in the treatment of morning sickness, as well as the drug. Then 20 years later, you can't protect the drug anymore because it's known, right? But what is new is a new use of a known substance, a new use of thalidomide. And so then they got the second patent for the second medical use, which is the use of thalidomide in the treatment of leprosy. That was new, hadn't been described anyway, hadn't been known. So you can take something that is known and you can apply a second use to it, and it's patentable. Okay, so the European Union is said that the first medical use of a known substance must be claimed in the for use type format of claim, and that would be thalidomide for use in the treatment of morning sickness, and then substance A for use in a method of treatment of B, right? Substance A being thalidomide for use in the treatment of B being morning sickness. Okay, and that the second medical use of a known substance cannot be claimed in this form. But I think that's largely been, again, that's like a hierarchy. Like I think we've moved on from that judgment. Yes, Elon Transdermal says that, but in practice, Elon Transdermal says that if you wanted to claim thalidomide for the treatment of leprosy, you'd have to claim it along the lines of in a Swiss type claim format. I don't know why they call it Swiss type claim. And that such a claim would be the use of thalidomide in the manufacture of a medicament to treat leprosy. So it's just semantics. But the bottom line is that you've got these for use type claims and you've got these Swiss type claims, and you can claim second medical uses of known substances. So that's an important distinction. You can claim the use of something when it's already been described for a first use. You figure out it's useful for a second use. That's what you can claim that. So that's a very important aspect of it. So I would strongly advise you go and read the whole of section 2511 and how it's described in Dean and Dyer, and then you can sort of put it all together and let me know if you have any questions, because it, as I say, it all comes back to the theory, and we sort of how, you know, it's in the interest of society that we practice these things, and it's not in the interest of society to be suing doctors, but it is in the interest of society to be recycling drugs, particularly if you've got a way to kind of figure that out. Okay, guys, the next thing we have to talk about is novelty, inventiveness, and utility. And I'm reckoning that's probably about another half an hour or so, maybe 3/4 of an hour. But what I'm going to suggest now is that we all take a 5-minute break. I just want to go get a glass of water and stuff. So I will be back online in about 5 minutes at about 25 to 11. And then we'll push through till about 11:15, and then we'll call it quits, if that's okay for today. We'll have covered everything that I wanted to cover. It's just novelty, inventiveness, and utility still to go. But I think I just need a quick 5-minute break, and you probably do too. So I'll see you back here in about 5 minutes. Yeah, all good? Okay, cool. I will see you guys now. Okay, and we are back. I hope everybody's there. If you're not there, put up your hand. Okay, cool. All right, just going to push through for the last half an hour, 45 minutes or so. We're going to talk about novelty, and we're going to talk about inventor step, and then we're going to briefly talk about utility. Utility's super easy, and we've really covered it up until now. So you will recall earlier when I was talking about the requirements for patentability, I said that, you know, it has to be novel and it has to be inventive. So your proposed solution has to be novel and has to be inventive. So let's talk about novelty. So South Africa has what is called absolute novelty, and this is set out in sections 25.5 and 25.6 of the Patents Act of 1978. So again, when you read section 25, which is really important and, you know, is underpins today's lecture, that is a very important part of it. So I'll just read section 25 because it's pretty self-explanatory, but it is really important. So an invention is deemed to be new if it does not form part of the state of the art immediately before the priority date of that invention. The priority date of an invention is the date on which the first patent application in which the invention is disclosed is filed anywhere in the world. The state of the art, and here we go, this is 25.6 or 25.5, I think. The state of the art is defined as comprising all matter, whether a product, a process, information about either or anything else, which has been made available to the public, whether in South Africa or elsewhere, anywhere else, not only in South Africa, by written or oral description, by use or in any other way. So that's section 25.6 of the Act. Stated differently, the state of the art includes anything which was possible for any member of the public to gain knowledge of and which could freely be disclosed without a breach of confidence, either express or implied. Okay, so that is a very high bar. It's anything which has been made available to the public in any way, shape, or form. So a lecture given in Mandarin in Shanghai, and any member of the public could have attended that lecture, it's public domain, and it can prevent the grant of a patent because it's got to be absolutely new. You have to be the first guy in the history of humanity to have suggested this as a technical solution. That's how high the bar is. That's pretty high, right? The first guy in the history of humanity can never have been made available to the public prior to the day on which your priority application is filed. You remember the priority is the first filing in terms of the Paris Convention. That's the date by which novelty is judged. So anything which is published before the date on which you file for your patent, that is taken into consideration in judging novelty of your invention. On the day is fine. If you and somebody else think of it at the same time, on the same day, your invention is not said to be anticipated, okay? It's just before, not on. But it's anything around the world. So one of the big problems actually that we encounter, one of the most common problems, is that somebody might have thought of a very cool invention, right? But he's made it available himself through trying to get investors, or maybe he's a scientist or an academic working at a university and he's under pressure to publish a paper, or he's under pressure to present a poster at a conference or something like that. So he puts it on the poster, and then it's made available to the public. And even though it was his invention, he was the one who made it available to the public, and he is the one who's ultimately responsible for it being anticipated and not being patentable because it's no longer considered new. So that's quite tricky. So as a patent attorney, we spend a lot of time educating our clients to say, this is how easy it is to shoot yourself in the foot when it comes to your inventions. So you've got to be really careful about this. So most universities, almost all corporates, have like a gate that if you want something published, if you want to present a poster, it has to go past the patent attorneys, and they will look at it and say, patentable, maybe we should hold this back, because if you publish this, you'll deny the invention novelty subsequently. So that's really important. Okay. So Macaulay Corporation versus Brickell, he goes on to sort of qualify dealing with the meaning of the term made available to the public, and describing the concept of absolute novelty. There are exceptions to the general rule of novelty. There are certain things which might not have been made available to the public, but are deemed being made available to the public, which is a bit sneaky and a bit tough. So it's really important as a patent attorney, as an inventor, as a patent applicant to be aware of these. And the two most important ones are secret use of an invention, but on a commercial scale in South Africa. So this is something which is a bit of a dogleg in our law, but you have to know it. And it basically goes along the lines of secret use of an invention in South Africa for commercial purposes, which is to say an invention which is kept confidential is considered to be novelty destroying if the reason for keeping it confidential is financial gain. For example, if a process has been carried out in secret for several years in a South African factory, and the process relates to the manufacture of a chemical compound, which is then sold to the public, then the novelty of the process is deemed to be destroyed and it cannot later be patented. And again, this is, it makes sense because you can't have your cake and eat it, right? You can't make and sell an invention and then sort of extend the period of monopoly and then suddenly wake up one day and say, oh no, I do want to get a patent for that. You've either got to keep it secret or you've got to patent it. You've got to pick a side. And an example of keeping something secret would be the formula of Coca-Cola, right? They could have patented it 120 years ago, whenever they thought of it, or they could have decided, no, we've got a good chance of keeping the secret. It's very difficult to re-engineer the final product to kind of analyze it and see what goes into it. Nobody will be able to figure that out. And it's true. 120 years later, nobody knows exactly what the formula of Coke is. They've come close, but for Coke, it was the right decision to keep it secret. But you couldn't keep it secret for 20 years and then patent it. That's not allowed, okay? Particularly if you've been making and selling it for commercial purposes. So even though something technically has not been made available to the public, the fact that it's been commercialized, it's deemed to have been made available to the public. Okay, so that again makes sense, right? It's just saying you can't have your cake and eat it. Pick a side, bro, early on. The second one, a little bit tricky, but you can also understand how it works. Okay, so imagine this scenario. You, myself, and Tabiso, working completely independently in different parts of the world, come up with the same invention. Not that uncommon, actually, because a lot of inventions are standing on the current technology, and we're all addressed in solving the same problem. So it's not unusual to come up with the same solution, even though you're working completely independently. There's no collaboration, nothing like that, but you come up with the same idea. Tabiso files his application on the 1st of January 2022. I file my patent application 3 months later on the 1st of March 2022. Okay, 2 months later. I don't know what is in Tabiso's application, because one of the important aspects of patent law, which we will come to when we talk about the formalities next week or in the next lecture on the 19th, is that patent applications actually lie secret for 18 months. So I have no idea. I might know. All that when Tabiso makes his application, it just says Tabiso made an application on this day for an invention and it's entitled monoclonal antibodies. That tells me nothing, man. I'm working on monoclonal antibodies too. I see Tabiso's file. That's like, I don't know what's in there. I'm not going to see that text for the next 18 months until June 2023. But I filed my application anyway. Turns out that Tabiso and my applications are basically identical. When it comes time to get my application granted, Tabiso's will have published in the meantime. And whatever's in Tabiso's application is considered to anticipate mine, even though there's no way I could have figured out what was in Tabiso's application. Just bad luck that we had invented the same thing, and I got there last, okay? So it's first past the poll. First to file is the winner in patent law. So that sounds really unfair, right? Because there was no way that I could have known. It's not technically available to the public. Well, it is in the sense that it wasn't available to the public on that day, but by filing his application, Tabiso had set in motion that it would become public domain in 18 months' time. So it's kind of considered to be public domain, but only for the purposes of novelty, okay, at that time, not inventive step. So the most minor difference between my disclosure, my invention, and Tabiso's, I can protect. But to the extent that Tabiso's is identical and there are no differences, unfortunately, Tabiso got there first, and my invention is considered to be anticipated by Tabiso's filing. So a bit tricky, not all that fair, but it is what it is, okay? Sally, yeah.
Yeah.
You're on mute, Sally.
Sorry for that. Okay. So I'm asking.
Sure.
What's the remedy that you have? Can't you rely on honest concurrent use or prior use, just like in trademarks?
No, that's a great question. Honest concurrent use exists in some patent laws around the world, but not South African, unfortunately. So under honest concurrent use, if you've been doing exactly what is described in a patent, on or before the date of that patent application, you can continue doing that. But that is a provision that doesn't exist in South African law. So unfortunately, it is a case of sorry for you. In the case where Tabiso got there first, it's just I have to take it on the chin. I can protect the differences between my and Tabiso's application, but to the extent they overlap, Tabiso wins. And that is the harsh reality of it. Okay. In terms of South African law, yeah. The final Rudo, yeah.
Okay. All right. Sorry, I was just unmuting myself. So I don't think I quite understood what you said about not being able to protect the patent once you've commercialized it. It needs to be a decision you make before you start commercializing it, right? So in the case where you submitted your application, can you then start commercializing it before it's been granted, or you have to wait?
No. That's a great question, Rudo, and the answer is straight up. Once you've made your patent application, you can go wild. Okay, you can start advertising, making, selling, using, going crazy. But if you do that commercially before you file your patent application, it's considered to be making it available to the public. It would anticipate your application, and therefore your invention would no longer be patentable. But if you file your application first, after that you can go wild. So yeah, great question.
Thank you.
Okay. The other aspect is about an exception is whereby if you tell somebody something under obligations of confidentiality, so you would have heard of non-disclosure agreements, you might even have come across them in your LLB. Let me tell you, when you work in practice, we use them all the time. Okay, so you've got an invention, you want maybe an investor or something, you want to show them, but you haven't filed your patent application yet for whatever reason. You maybe can't afford it. It may be the invention is still, you haven't got it quite right. It's a little bit too early to file your patent application. So you want to show these guys and maybe get some input or whatever. You say to them, listen, I'm going to show you stuff. I'm going to disclose confidential information. I want you to sign this and whereby you undertake not to make it available to the public after I've shown it to you, not to disclose anything confidential that I tell you. They sign it. You show them, they say, hey, that's cool. And then they go and do it anyway. They go and, advertise it or present it as their own or whatever like that. Such a disclosure is unlawful because it's a breach of the confidentiality. And so, so a second exception arises when a patentee can show that information was disclosed without his knowledge or consent, and the information was derived from him. In this case, the disclosure will be excused, provided that the patentee applies for patent protection as soon as possible after discovering that the invention has been so disclosed. And that is section 26A. So that's an important one. And then finally, you can actually use an invention in South Africa, but only by way of reasonable trial and or experiment, technical trial and or experiment by the patentee. So you can get it out there, you can see if it works, but you can't commercialize it. It's got to be technical trial or experiment. So the word reasonable is in there, so you can see there's always going to be a squabble about what's reasonable. It's a question of fact, and it's determined by the circumstances surrounding the case. So those are the exceptions to novelty. It's those co-pending applications, the one by Tabiso and the one by me. It's the secret commercial use in South Africa. It's the second exception when the patentee can show it was disclosed unlawfully, and finally with reasonable technical trial and experiment. So when we say absolute novelty, it is absolute in the sense that it's global in any language, in any format, but you've always got to remember there's a couple of exceptions to that rule, in the sense that there are a couple of things where it's considered to be public domain, even though it's not technically public domain, and there are a couple of instances where making the information available to the public are excused. Okay, so it's important just to see the concept of absolute novelty in terms of those exceptions. Okay, now we're going to talk about inventive step. Okay, so now inventive step, so novelty is pretty black and white, right? It's binary. It's either been made available to the public or it hasn't. Inventive step is normally only sort of investigated when you've established novelty. Okay, you grudgingly accept that the invention as claimed has not been made available in its present format, and now you're looking at that difference between what's claimed in the patent and what has been known, what's the prior art, which is to say that which has been disclosed to the public. And so now you've got to figure out whether that difference is inventive or if it's obvious. Okay, so inventive, lack of inventive step, obviousness, non-obviousness, they're all the same thing. Okay, and basically if that difference is trivial, then it's said to be obvious and you fail inventive step and you won't get your patent granted. But if it's said to be inventive, then you do get your patent. So how on earth do you go about figuring out whether something is inventive or not? And yeah, so an invention is described to involve an inventive step if it is not obvious to a person skilled in the art, having regard to any matter which forms immediately before the priority date of the invention, the state of the art. Okay, so what you've got to do is you've got to figure out somebody who is skilled in the art. Okay, so if you're, like working with nuclear science or something like that, then you've got to speak to a nuclear scientist. You can't just go to, a car guard and say, hey man, do you think this difference is obvious or do you think it's trivial? You've got to go to somebody who's skilled in the art, who knows their stuff when it comes to this particular subject matter of the invention. And there is a case, Ensign Brickford versus AEC Explosive, where they set out what they said was a simple 4-step test to be applied when determining whether an invention is inventive or obvious. Okay, and that is step 1. What does the patentee, what does the applicant say is the inventive step? Okay. Step 2, what was the state of the art at the priority date of the invention? Okay, because it's always the priority date of the invention. Step 3, what's the difference? Okay. And step 4, having regard to this difference, is the difference obvious to the skilled person? Now, yeah, okay, those first 3 steps are pretty obvious, right? And the 4th step is not helpful, because how do you figure out if something is obvious or not? And the answer to that question, I suggest, is that is there an effect that is associated with that point of difference, and that effect is not capable of being predicted, or you couldn't have figured out that it was going to happen. Okay, so let's have an example. It's the easiest way to explain this, because by just talking about it in theory like this, we're not getting anywhere. Okay, so let's talk about novelty, and then we'll talk about inventive step, and we'll apply it to a very simple example. So say we lived in a world where bicycles were known, bicycles were common, but there was not a single instance of a green bicycle. Okay, bicycles were red, bicycles were blue, bicycles were purple, bicycles were yellow, but there has never in the history of humanity been a green bicycle. So you come along and you say, okay, I am going to make an application for a patent for a green bicycle. So your claim is simply a bicycle which is green. Full stop. Now, when that claim comes to be examined, the examiner will look at all the patent literature and think, wow, this guy's right. There are no green bicycles. I can't find one on the internet. Can't find one in all the literature on bicycles. There's just no green bicycles out there. But he's going to say, but come on, man. We've got blue bicycles. We've got red bicycles. We've got yellow bicycles. It's trivial just to paint a known bicycle green. Bicycles are known. Green paint is known. It's non-inventive. It is obvious to take a different colored bicycle and just paint it green with green paint, which is known. So that would be the argument as to why a green bicycle is obvious over what's known before. The difference is trivial. Okay, but this is where patent attorneys come in. Okay, because I'm the patent attorney who is acting for you, has invented a green bicycle. I write this patent application. I claim, as my first claim, a bicycle which is painted green, or a green painted bicycle. I get this back from the examiner. Your difference is trivial. It's non-inventive. I grudgingly acknowledge that your invention is novel, but the difference is so trivial that it doesn't rise to being an inventive step. And that's when I write back and I say, I have evidence that there is a technical advantage to painting your bicycle green. We did an experiment on the Isle of Wight, which has a population of 10,000. And we put 500 red bicycles on the island, and we put 500 green bicycles on the island. Everybody rode them around. And after 6 months, we noticed that 20% of the red bicycles had been stolen, but only 5% of the green bicycles had been stolen. And we think it is down to the color, because if you lend your bicycle against a hedge, when it's green, it's camouflaged. People don't see it. They don't steal it. If you leave it lying on your lawn, people don't see it because it's green and it blends in. But red bicycles are seen, and so they get stolen more. Green bicycles blend in to the hedges and the lawns and where you leave them, so they don't get stolen. So that is a technical advantage that comes from painting your bicycle green. It's not predictable. We didn't know that. But the problem of bicycles getting stolen is solved by painting your bicycle green. And that is the inventive step that comes from painting your bicycle green. Yes, just a simple color change. It is trivial at first glance, but when you look into it and you look at the technical advantage associated with that point of difference, well, that's when you get inventive step. And that's how inventive step is sort of approached. You've got to have a point of difference from what's known in the art, otherwise you're not novel. And that point of difference must give rise to a non-predictable technical advantage. Boom, then you solved inventive step. And that's basically how it works, okay? The difference between novelty and inventive step. I hope that kind of explains it. It's that's a really trivial example, but I think it explains the concept, the difference between novelty and inventive step very well. But let's stay on this example for a little while because it is interesting. If you want to be difficult, you want to say, well, what is green? Okay. And it's a good question. What is green? Because there are many different shades of green, right? And when does green become yellow? And when, so anyway, can any of you name the 7 colors of the rainbow in order? Anybody? No? If you start from one end of the rainbow and move across, those are the kind of like primary colors, right? So anyway, for those of you, this is your fact of the day. You can remember the 7 colors of the rainbow and the order in which they appear by memorizing the following word. And the word is Roy G. Biv. R-O-Y-G-B-I-V. Roy G. Biv. And those colors are red, orange, yellow, green, blue, indigo, violet. Okay. Roy G. Biv. Red, orange, yellow. Okay. So the 2 colors on either side of green are yellow and blue. Okay. And if you look at a rainbow, the colors like bleed like that. So where does green begin and where does blue begin? Where does green end and blue begin? So there is, believe it or not, a way that you can define what is green and what's not. There is a book out there. It's a reference that paint manufacturers and the like have come up with, and it's called the Pantone Reference Grid. And it is a grid of thousands and thousands of colors, all sagging from red all the way through to violet, the colors of the rainbow. And it's a big, thick book like this. Each page has got 6 or 7 of these colors on it. Each color, each block of color, differs slightly from the one next to it as it moves through the rainbow spectrum, okay? Becoming greener, becoming bluer, etc., etc. And each of those pictures has a number, and it's called the Pantone number. So every color which is discernible to our eye has a Pantone reference, okay? And so when you write a pattern specification and you say something is green, what you have to do is you have to say, when I say green, I mean Pantone references from X to Y. And if it falls outside of that Pantone reference, it's not green as I define it. And if it falls within that Pantone reference scale, then it is green as I define it. And that's how, we define the color green. And that's where, so we can point out exactly where yellow ends and green begins, and exactly where green ends and blue begins. So that's the art of drafting patterns, because words like green, words like high, low, hot, cold, they don't have a measurable meaning. But it is so important in patent law to have a measurable meaning, right? Because that claim defines whether somebody is infringing or not infringing your invention. And that has to be as precise as possible. So let's look at the word bicycle. So bicycle is quite limiting, okay? Because it's got the word bi in it. It means 2. So if I say bicycle, I'm excluding monocycles, because that's only got 1 wheel, and I'm excluding tricycles and quad bikes, because they've got 4 wheels. So I'm limiting myself to 2 wheels. So do you want to limit yourself to 2 wheels? We're talking about a green bicycle, but do you want to include tricycles? Do you want to include monocycles? I don't know. You need to talk to your clients about that. But when you use the word bicycle, you've got to understand that you're excluding tricycles and excluding unicycles. So bear that in mind when you're drafting your claim. Every word in a claim has to be really considered and thought about, because it has a meaning and you have to be really careful about that meaning. The other thing is, when I say bicycle, what are the minimum constituents of a bicycle? Well, it's got to have 2 wheels. Does it have to have pedals? Does it have to have a chain? Does it have to have a saddle? I hope it has to have a saddle. I don't think it's fit for purpose if it doesn't have a saddle. But I don't know, does it have to have a bell? Does it have to have a light? Where does the commonly accepted meaning of bicycle, begin or end. So you can see how this is a claim which has got 5 or 6 words. A bicycle which is painted green, 6 words. But we're already in a fight about what constitutes green, what constitutes a bicycle, does it have a saddle, etc., etc. So you can see how quickly and how complex patents get. But I'm digressing a bit from the concept of inventor step. But I hope you understand inventor step. When you read Dean and Dyer, and good dear God, when you read Burrell, it's really easy to get completely caught up in what constitutes an inventor step and what is not inventor step. But when you just realize that as long as you've been able to establish a point of difference from the prior art, and you can attribute a technical advantage to that point of difference, you've solved inventor step. So there are the two big ones: novelty, inventor step, all good. And, you know, we take it from there. So, and, you know, the test for obviousness as set out in Ensign Brickford, yeah, it's helpful, but really it all turns on the fourth step, which is what we've been talking about today. So hopefully that's kind of been, you know, sort of set out clearly. If you have any hassle with it, if you don't get your head around it, particularly after a day or two that you've had a chance to think about it, give me a shot. I mean, we can talk about it. But it is one of the fundamental aspects of patent law that you have to understand. Now, one interesting thing about the difference between novelty and inventive step is that there's this concept of mosaicing. So, you know, mosaic is made up of little bits of tile which you put together and you get a picture. Okay, that's mosaicing. You cannot use mosaicing to destroy the novelty of something. If something is said to be anticipated by the prior art, it has to exist in one document and one document only. But you can mosaic to get an inventor step argument. So you know, a green bicycle would have to have been described in a single reference, a bicycle which is green, that's fine. And if it was in more than one, you can't combine to destroy the novelty of an invention. But you can take two completely different documents and put them together to create a lack of inventive step argument. So you could say, I've got two documents here, one which talks about bicycles, albeit only red, and I've got another document here which teaches green paint. And it would have been obvious to take green paint and apply it to the document, and in so doing, mosaic two documents together to get a picture. So it is possible to mosaic for inventive step arguments, but it's not possible to mosaic for novelty arguments. Okay. The last thing I want to talk about today is that's lack of utility. Now, I spoke about this earlier, and it's really just 5 minutes quickly, and that is a lack of utility. The Act provides that a patent can be revoked if the invention, as set out in the specification, cannot be performed or does not lead to the results and advantages as set out in the specification. So you've got to be quite careful, because, you know, the invention could work, but if you say in your specification it solves world hunger, and it only solves world hunger in Africa but not in Asia, your invention can be revoked because doesn't work according to how you said it would work. It still works because it alleviates hunger in Africa, but you said it would alleviate hunger around the world, and it doesn't do that. So it's inutile. It doesn't have the utility that you said it did. So you've got to be super careful when drafting these patent applications that you don't go big with what you say it can do. You can just say, it may ameliorate the problem of world hunger. Now, ameliorate is a great word. It's a word that patent attorneys use all the time, and it means make better. Okay, so that doesn't mean I didn't say I'm going to solve it. I just said I'm going to make the problem a little bit better. And so it's really important, because you can actually shoot yourself in the foot with a patent application by saying it does something when it doesn't do exactly what you said it would be. So you have to be like quite circumspect. You have to be quite humble about how you describe your invention, right? Because if an invention cannot be performed, it is said to lack utility, and the patent will be invalid. So, I mean, if it doesn't work at all, the pencil adapted to fly to the moon. Well, that's one thing. You're obviously not going to get a patent for that. It just doesn't work. But you've also got to be careful that you can set yourself up for failure by saying it doesn't work according to how well you said it would work. So there's a lot of pitfalls in drafting patent applications. Claim drafting is very important, but the manner in which you frame your solution to the problem and what you say it'll do can also be a problem as well. So there's quite a good sort of summary of in utility, and that's in integrated mining systems. But I won't quote it there, but I'll just ask you to read it. Okay, so that was in utility. So today we spoke about the history of patents, patents in context, you know, how they work with trademarks and designs. We spoke about what is a patent, you know, the philosophy behind it, what is an invention, and you know, it's basically what is not an invention as defined by the Act, the concept of novelty, the concept of inventiveness, and the concept of utility. Those are all explored today. So that is lecture 1 in a nutshell. I cannot express how important it is to read Dean and Dyer, and you can see I've largely followed it quite closely, but I want you to be familiar with the cases there as well. The next lecture will be in 2 weeks' time. That'll be procedure for obtaining a patent, 19th of March 2022. That's going to be in Joburg, and I want us all to meet. So I will be in touch with you closer to the time. I will give you an address to meet at Melrose Arch, and we will all go and we will sit in the boardroom and we'll have a proper ordentliche lecture with coffee, and you can ask questions and we can meet each other and everything. And I think that's going to be great. I really look forward to that. In that lecture, we will be discussing the procedure for obtaining a patent, and you will see that those headings are all reflected in Dean and Dyer. So I would like you to have pre-read Dean and Dyer and maybe have had a chance to look at some of the case law, which is set out there and which is set out in your case law, which I'm sure you, the case law reading lists, which you will have all got, and particularly the ones in bold. Those are the ones which are quite important. But other than that, I think we're done for today. If you have any questions, please let me know. Otherwise, I can address them now, or if they occur to you in the fullness of time, tonight, tomorrow, next week, drop me a mail and I will answer them with pleasure. What I'm going to do is I'm going to stop recording now, and I'm going to upload this to YouTube, to the YouTube channel. I'm also going to upload it to Blackboard, but I'm really not going to upload anything else today. None of the cases or anything. You guys must get the cases and read them. I'm just going to upload the video to Blackboard just so that Daneo can have a look at it. And if there's anything that you guys don't understand, you can come back and have a look at it as well. Otherwise, I think we're done for today. We've been recording for 2 hours and 17 minutes, so it's quite, you know, this is generally how long I think the lectures will be. It'll be rare that they're much longer than this one. I know I set aside until 12, but that's just for a worst case scenario. I think there's only so much patent law that you can take on a Saturday morning, and there's only so long that I can speak for, and I'm at the end of that time period. So guys, unless there are any other questions, we are done. I will be in touch, and I really look forward to seeing you in the flesh, as it were, in 2 weeks' time. Any questions before we go? Sally, yeah.
Yes, Prof. Earlier when you started the lecture, you spoke about these issues which make the big five in IP. And then you mentioned that it's patents, registered designs, copyright, trademarks, trade secrets.
Yes.
How is it different from the know-how?
Trade secrets, know-how, and confidential information are all basically the same thing. They're all put together in the same basket. And so I often refer to it as know-how as a collective term, or some people prefer trade secrets as a collective term, but it's all basically a body of information which is useful and which is not known in that context. So it would be operating parameters for manufacturing processes. It would be customer lists, customer pricing lists, things like that. All stuff which is known to that company, but not generally known to the public. That all falls into the 5th category of the Big Five.
Okay, thank you. So which law regulates these trade secrets? Because if it patents, I understand the Patents Act, if it trademarks, the Trademarks Act.
Yeah.
So trade secrets, where does it?
Well, trade secrets would be largely, you have to manage them. There's no specific act which covers trade secrets. Like, you're quite right, there is a Patents Act, Trademarks Act, Designs Act, and a Copyright Act, but there is no act for know-how. But because know-how is just so popular, and every company has know-how, every company has confidential information. It's just, you know, it's ubiquitous. It's out there. It exists, and it's managed through contract law. So that's mainly and non-disclosure agreements. And so it's really a branch of sort of common law, but there's no way to sort of, the only way you can effectively leave confidential information is to manage it properly. And that is done by way of obligation, which is put from one party onto the other. So it largely falls under contract law, employment law, but it's always agreements. And it's always understanding that the information is confidential and managing it accordingly, such that it's only disclosed to people under obligations of confidentiality. So there's no act per se, but it is important to recognize it as an important aspect of law and to manage it accordingly through contracts.
Okay, understood. Thank you.
Okay. Any other questions? Rudo, Tabiso, you all good?
Nothing my side.
Great. All right, guys, let's call it for today. Thank you for your attention. I think we covered a lot of ground. Hopefully you guys followed it. To the extent you didn't, give me a shout if it doesn't bed down in the next day or two. And then I'm going to be in touch, and we'll see you in 2 weeks.
Thank you, Prof.
Thanks, guys.
Thank you.
Okay.
Prof.
Thanks, Prof.
Go well. Have a good
Bye.
week. Cheers.